Hey everyone, today's conversation is going to be about reimbursement. I've had my guest on several times before. He is a prolific speaker. He quotes the most ridiculous 1990 to 2000 quotes in movies. He has bad taste in movies, but they're just so good. If you're interested in learning more about reimbursement, how that affects the pharma industry, you probably are going to care about today's discussion. If you're an HEOR, if you are in talking to insurance companies, this is going to be really, really interesting. I do want to talk a little bit about our guest. He is the National Managed Care Practice Leader for WTW, which used to be called Willis Towers Watson. He's the chair of the ABA Managed Care and Insurance subsection, which is very surprising to me because I know he's actively avoided leading anything as long as he can help it. So he's finally been forced into a leadership role, despite being about 15 years overdue for it. He can be reached on LinkedIn or at his email at kenneth.white@willistowerswatson.com. As you can tell, his email has not changed yet. And WTW has paid a lot of money to get that WTW.com user URL. So expect that very soon.
All of the swag still has the other name on it.
They have to send you new swag. I mean, I think that's
I know. I'm waiting. I just want a new email address.
It's going to be a lot easier than typing out Willis Towers Watson.
Yes.
This is the Darshan Talks live stream. I'm your host, Darshan Kulkarni. My guests and I are both attorneys. I'm also a pharmacist, and I advise companies with FDA-regulated products. I do have to say, neither one of us is giving any kind of legal advice. This is also not clinical advice. And go talk to your own lawyer or pharmacist to get more information. These are considerations, these are conversations, and they don't necessarily reflect the opinions of the host, the guests, our employers, or our clients. If you like what you hear, please leave a comment, please subscribe, please share, please reach and ask questions. I know I'm already fascinated by the conversation I'm going to have. I'll be honest, usually reimbursement conversations scare the crap out of me because I don't know what I'm talking about. But this is one of those areas that deeply affects what I do. So this should be really exciting. If you're interested in intellectual property, you're going to care about today's conversation as well. So you can reach out to me on Twitter, Darshan Talks. Go to our website. Go to my website, darshantalks.com. Now that we've got the preliminary stuff out of the way, hey Kenny, how are you?
Doing great, Darshan. How are you? I understand that things are going well. You know, it's a new year. We're still trying to manage the whole COVID. This COVID, that COVID, the other COVID thing. We have a mask here somewhere I could put on if we need to have a mask on this. I'm supposed to go to Argentina soon, so I have to figure out how to get a PCR test and get my result back in 2 days. That's going to be my biggest headache, coming up. So
you'll find them because they are out there. My dad had to do that very recently. The problem you're going to face more is just going to be, I believe the biggest problem we recently heard about was Ted Cruz pointing out that he couldn't find a ticket to go to Mexico at a price he was willing to pay. So I think your price might be the biggest concern. And that's not a political statement. I just think it's funny for him to talk about it when he got caught having problems earlier.
Yeah, well, optics.
Optics, exactly. It's all about the optics. Speaking about optics, we talk a lot about drug pricing. We talk a lot about the cost of drugs. There was a recent situation in the Amarin versus Hikma case, and I'm going to bring it up so that everyone can see it. Kenny, can you tell us a little bit about this case? Why is this a big deal? And you presented on this recently.
Yeah. So to the New York bar. So let's drop back a little bit because we mentioned reimbursement. This is reimbursement related because the claim against the defendant who's not in the title up there is Healthnet, which is a subsidiary of Cintine. They were not originally a defendant in the case. They were added a year and a half into the litigation. The issue being how they handle drugs on their formulary, what they pay for, and how. Mm-hmm. So many people in the audience are probably familiar with skinny labels for generics. So you have the main drug that has a patent. The patent is running out. They've been unable to figure out any way of messing around with the patent or changing the molecules to keep the patent going, and somebody has come up with a generic version of it. This particular drug was called vascepa or
Vascepa.
vascepa. Thank
Yeah.
you. Cardiac related drug that
It's basically fish
the
oil.
the original version of it, the Amarin version, was FDA approved for two different purposes. The generic Hikma version of the drug was FDA approved for only one of the indications. So after the Teva case had come out a couple of years ago, I think it was GSK versus Teva, they were using skinny labels to indicate that the drug was authorized for this particular purpose, but they weren't really discussing that, oh, by the way, the original version of this drug is also authorized for this, and we're not authorized for that yet. But so the drug was immediately put on formularies because it was a generic form of another drug that was already being used. And obviously it went down to tier 1 because all generics, for the most part, if it is a usable drug, useful drug, will make it to tier 1 in a formulary for a managed care plan, which obviously means the cost to the member was much less than the cost of a tier 3 or tier 4 drug. And they had prior authorization in place for the medication, because the type of drug, they weren't checking the patents. They were simply making sure, according to the formulary, that the condition that the patient had for which the drug was being uh, uh, prescribed met the medical criteria for needing that kind of a drug. So it went through a prior authorization process. Centine has its own internal company called Evolve that handles formulary and prior authorization consulting for Healthnet. They use, I think, either Caremark or ESI. I'm not sure which one of the big PBMs for the mail order and stuff like that, but the internal consulting for the formulary and the prior authorization was handled by this other subsidiary of Centene. So drug manufacturer sues generic company for patent infringement. Generic comes in back in and goes, no. We're following the rules with regard to skinny labels. We're not, violating your patent. A year into it, and in the first amended complaint, they add Healthnet. How they picked Healthnet out of this, I'm not really sure, other than the fact that they had at one point in time sent a letter to Evolve, not to Healthnet, saying, oh, by the way, we're in litigation with Hikma, and the patents weren't identified, nothing else. They just said we're in litigation with them over this drug, and so Evolve had that letter, plus they were doing the prior authorization.
Was it a cease and desist, or was it just a notification?
It was more of a notification. It wasn't a cease and desist. They weren't telling them they couldn't do anything. They were just saying that they were in litigation with them over the patent. But the patents weren't identified.
Right.
And I know that everybody on this probably knows what an orange book is. I'm far more familiar with the blue book because we had to use them in law school. If you remember back that far ago, I probably have one lying around here someplace, but I don't have an orange book lying around. And I can assure you that most pharma departments at managed care companies don't have them lying around either. Because remember, most managed care. What was that?
The orange book is available online for free.
Oh, well, doesn't mean I read it. I mean, War and Peace is available online. Doesn't mean I've read it all. But the other part of that is that managed care entities are not in the business of policing other people's patents.
Correct.
So, if you walk into the cafeteria at the managed care company and you ask somebody, can I have a Coke, and they give you a Pepsi, tough. The
Right.
Coke police are unlikely to come running in to protect their patent, but maybe. In
Yeah.
this case, you have to remember that most managed care companies are not huge.
Right.
I mean, you
Wait, is
have
that true?
the Blue Cross, you have United, you have Cigna, you have Humana, you have Centene, and you have the Blue Cross Blue Shield Association. But all of the rest of them are small. There are managed care companies out there that have 5 and 10,000 covered lives, not 10 million covered lives.
Interesting. I didn't realize that. Okay.
Plus, you have Medicare Advantage plans out there that are provider owned that are very small. They don't have the wherewithal to do patent policing duties. So the case went to a motion to dismiss in front of the magistrate, and then it went to the U.S. District Court because the case is pending in Delaware, actually. And the judge let Hikma out of the lawsuit, saying that they hadn't violated anybody's patent. But then denied the motion to dismiss filed by Healthnet, basically on the basis that somebody had to pay, that there was an infringement of the patent. Now, the claim against Healthnet is not patent infringement. The claim against Healthnet is inducement to infringe a patent,
Right.
which typically includes there has to be a direct infringer. And in this case, the alleged direct infringer was physicians prescribing the medication and pharmacies, filling it and members buying it.
Right. Right.
They couldn't hook into the generic guys because they're out now.
Right.
So they're alleging that Healthnet has induced physicians to prescribe a medication for a clinical indication for which the FDA has not approved it.
Right.
And you're supposed to have knowledge of the asserted patent. And of course, Amarin says that their letter to Evolve satisfied that.
Mm-hmm.
You had to have active knowing encouragement or assistance to another person's direct infringement and knowledge that what you're doing is probably going to constitute infringement. I can assure you that there's not a health plan out there that knows this kind of stuff or
Right.
is concerned about it. I mean, maybe Optum, but maybe United because they have Optum RX. Maybe Caremark for CVS Aetna. It's possible that you could put it on Cigna because of ESI, but these other entities, they just don't have that stuff. And you're talking about payment policies causing an inducement to infringe. Now, you well know physicians prescribe medications, then the prior authorization process takes place.
Right.
So how do you induce someone to do something they've already done? I don't tell you whether I'm going to pay for the procedure that you want to have, or the test, the diagnostic test, or the medication that has already been ordered for you until such time as there is a prescription for me to look at to tell whether or not it's covered. And in my opinion, I'm making benefit determinations. I'm looking at this going, this drug falls into that category. That person needs to have these criteria. They have those medical criteria according to the physician, and boom, we pay for it.
Right.
And I'm not going to look to see whether or not the physician is violating a patent by ordering a drug for something, because this. What's the percentage of drugs that are used off label for which they aren't authorized for anything?
A ridiculous amount.
So, I mean, how am I going to do that? The problem is this. If you're going to hold managed care companies of all shapes and sizes, including self-funded health plans, by the way, if you're going to hold them liable for policing patents,
Mm-hmm.
and they can be held in a lawsuit and potentially be forced to pay damages for patent infringement, it will be hundreds and hundreds of millions of dollars.
Right.
So in that case, what happens? The cost of healthcare goes up and up and up and up, and the cost of your insurance through your employer or through the ACA or through anything else goes up and up and up, because the health plan is now responsible for patent policing. And if they don't do it right, and they can be popped for a couple of $100 million or $1 billion, what happens if it's, Humira or, one of the other drugs that's out there that's, billions of dollars a year in revenue?
Yeah.
That's something that's untenable. The second thing is there's no insurance coverage for this, because in a managed care E&O policy and in a D&O policy that would normally be issued to a not-for-profit or for-profit managed care entity, patent infringement and inducement to infringe a patent are excluded wrongful acts. So there's no coverage for it.
I have so many questions that come out of this.
Ask away.
I think the most interesting thing that pops up to me is this cross-section between a part of the world that you are so intimately familiar with, which is reimbursement, but a part of the world that I know pretty well, which is off-label prescribing connected to the patent scenarios. And what I'm referring to is this idea that there's nothing inherently illegal, and we know this, even the FDA concedes this. There's nothing illegal about a prescriber prescribing the drug off-label. In fact, according to the FDA, that may very well, in many cases, be the standard of care. This is especially true in things like oncology. This is true in antibiotics all the time, et cetera, et cetera, et cetera.
Which is why they have prior authorization procedures to begin with.
Exactly right. So there are, as for people who don't know, there are multiple reasons you can get a patent. The manufacturer of the product would be completely would be covered theoretically as a inducement. If you were manufacturing the product in ignoring the patent, you might have an issue. In this specific scenario, Hikma was doing it, but that was completely legal because they were approved for one indication.
Right. So if Hikma was improperly selling a drug and
Correct.
violating a patent directly, or they were marketing the drug directly to physicians and other prescribers by saying, oh, don't worry about that FDA
Right.
stuff. This drug is just as good as that drug for both indications, not just the one that we have FDA approval for, then that would be inducement to infringe the patent.
Correct.
As opposed to direct infringement of the patent, which they could have also been doing. But in this case, the judge said they weren't doing either, because their label, they were using the skinny label concept and basically were parroting, the Amarin labeling,
Yeah.
and it's simply eliminating the other indication for which the drug was approved.
Which they're required to do by FDA regulations.
Right.
So here's my question. Going forward, does that mean that as it stands, if you follow this case, you, as a insurer, you now need to get a freedom to operate before you allow a drug on formulary every time there is a new indication?
Well, here, that's one. So we're at the motion to dismiss stage. So for those
Right.
lawyers that are on the podcast or listening, we're just at the motion to dismiss stage. For everyone else, the pleading stage, the complaint, admitted complaint, there were defenses raised. The judge bought the defenses of the generic drug manufacturer, but refused to let the managed care company out of the case, which now means we've got discovery. We'll have motions for summary judgment. Hundreds of thousands, if not millions of dollars, will be spent in defense costs before there is another opportunity for Healthnet to try to get out of this, which hopefully eventually will happen either at this level or at an appellate court level. But let's assume for a moment that this stays the law and then spreads from Delaware to other jurisdictions. You're going to have to, if you're a managed care company, somehow make accommodations for ensuring that you're not paying for drugs that are being used that
Off-label.
might violate a patent.
Right.
And it'll increase the cost of managing the drug system, which is already unmanageable and grossly, inflated. But I mean, it'll make that even worse. And then you've got, except for the biggest of the managed care companies, they're going to have to outsource that to someone else
Right.
because they don't have the bandwidth to try to do that. They probably got, a director of chief pharmacy officer and maybe a couple of other people on their staff to do this, or it's all been outsourced to, ESI or Caremark or OptumRx or what's the Prime Therapeutics, Ingenio, one of the other PBMs out there, and the PBM will have to take that into consideration, and then it will become their obligation, which will increase their costs. So their cost to the consuming public, meaning health plans and self-funded health plans, will increase, and the cost to the employer and the cost to the members will go up. All to protect a patent for a manufacturer that's already made millions and millions of dollars, probably off a drug because they've had the patent for a number of years. And now they're just shifting the burden of protecting their own patent to somebody else.
But the question is, so let's look at it from a different perspective. If I was a drug manufacturer, and
this is 2022, there can only be one perspective. You're not allowed other perspectives.
That is fair.
You can't do that.
I will be canceled at the end of this podcast.
Yeah, you will be canceled.
But so it's, let's say I'm a drug company and I go through the approval process. I spend up to $4 billion getting a product approved. Comes to market. I have 3 to 5 years to get the product, recoup my investment, make a profit. I've done that theoretically. I look at patent line extensions and sort of try to figure out what I can do. One of the things you can do regulatorily is you can go to the FDA and say, look, we've done all these studies. We think this drug can work for another scenario. So this is what we're going to do. This is the new drug this is the new dose. This is the new indication we're going to go after. That's the scenario as it lays out right now. What other companies have done is that when you've got the same exact drug moiety that's used, they come up with weird doses to address that. So a really good example right now, I'm a fat ass. So since I'm a fat ass, I take this drug called Ozempic. Ozempic is used for diabetes. And from what I've gathered, it's not the great, I don't practice clinical pharmacy anymore, but Ozempic is not the world.
They have great commercials.
I'm sorry?
They have great commercials.
Yeah, they do have good commercials. It gets better though. It's approved for diabetes. It's not the greatest diabetes drug, but it's supposed to be incredible for weight loss. So the 1 milligram dose, the 0.5 and the 1 milligram dose are approved for diabetes. And then you've got the 1.7 milligrams, which is approved for weight loss. And that way, the drug company can adjust and prevent a insurer from allowing interchangeability, because you're basically saying it's a different drug at a different dosage form that's not been approved. So you physician are using the drug in a way that's never been approved for that indication.
Okay, let's take that example right there and switch it into this scenario.
Right.
So let's assume there's a generic for Ozempic out there, and they're trying to tag on to the other things. It has FDA approval for the diabetes use. Yep. But since it's being used for weight loss, which is off-label, there's no FDA approval for it anyway, then the generic form can't come in and get FDA approval for something there isn't FDA approval for. Correct. But they're trying to, nudge it under the table, market it, whatever, and the manufacturer of Ozempic might go out and try to, protect its patent from those people who are inappropriately marketing a generic form of the drug. Sure. But if I'm a health plan, so I've got a formulary that Ozempic is at a tier 3 or 4,
Right.
Because, as you said, it's not that great of a drug for diabetes. So why would I want to have it low down? I'd rather encourage the use of better, more efficacious drugs
Yeah.
than Ozempic. Um, and if a physician is going to order the drug for an off-label purpose, then I have to make a decision. So if I am a health plan and it comes in and my formulary says that drug requires prior authorization, we only pay for it if it is in fact used for one, diabetes, and you have these criteria, otherwise we're not paying for it. They could do that, except in half the jurisdictions, if not more than half the jurisdictions in the US, managed care companies are legally limited in what they can and cannot do with regard to a legitimate prescription, because everybody was so afraid the managed care companies would get between the doctor and the patient and say that you couldn't use anything, except for the fact that most doctors don't know jack about pharmacology, and they are simply, writing prescriptions for things that they've been told at a conference or with the drug man rep
Whoa.
that came in, and
Whoa,
did it.
whoa, whoa, whoa,
No,
whoa.
it's true. They don't know.
There is only one opinion, correct? So okay, we'll just let go
Well,
with your.
no, the expert in the Teva case who came in and went, doctors, he testified, doctors don't read labels.
That's fair. No, doctors don't read labels.
They don't read labels.
You read everything else. You read
So,
up
I
to
mean,
date.
they've heard, and maybe it's probably correct that the drug is good for using it for this. But I mean, if they're going to prescribe it for that purpose,
Mhm.
in many jurisdictions and with many plans, particularly with self-funded health plans, or government-funded health plans
Mhm.
where CMS is making the rules, you know, I, as a health plan, don't have the ability to say, no, you can't have this. I can't
Interesting.
say the doctor can't prescribe for that purpose because that's the doctor's job. I mean, that was one of the biggest problems with the whole opioid crisis. Yes,
Yeah.
okay. People making opioids were, telling everybody it was great. They weren't telling anybody about the addictive nature of it. It went on and on and on for years and years and years, but nobody got a uh, legal dose of any of those medications without a doctor writing a prescription for it.
Right. Right.
And in some cases, they were writing thousands of prescriptions for it. And they
Right.
weren't all pill mills. They were just, oh, you need 30 units. Hey, your toe hurts, your tooth hurts, have some
Yeah.
more, whatever.
Give them the new standard of care. Yeah.
But those people have walked with no responsibility at all, for the massive number of prescriptions that were out there. Say, so if you look at this, for Ozempic, if your doctor says you don't have diabetes, but we want you to lose some weight, and this
Yeah.
medication is good for that, and it goes to your health plan,
Hmm.
and your health plan may be prohibited from saying you can't have it for that purpose.
Correct.
The
That
only
is
thing they can do is put it on a tier, on a formulary and say, look, you're going to have to pay more for it than you would some other weight loss drugs that are otherwise, on the formulary. But it's
which
not
I
like
think,
the health plan can turn around and go, look, it's not authorized for that purpose,
right.
so you can't have it. Because if that was the case, they'd deny 2/3 of the prescriptions out there.
They would, and that would be getting between, like you said, the physician and the patient relationship. The part that worries me in this is you're making the insurer not just a health plan insurer, but a patent insurer, uh, and that's not what the intent was. That's not what they're insuring against. That's
Right.
not what they signed up for.
You're putting a duty on a managed care plan.
Yeah,
Like I said, not all of them are United Health Group.
sure.
So you're putting an obligation on a health plan to do something that they should not be legally responsible for. And
So
the
go back.
consequences of making them legally responsible for it are significant.
They are. They are, and it sets off this chain reaction that we haven't fully contemplated. I think an interesting option is the argument you made, which is it really inducement or enablement? And I don't know how the patent law is set out. I don't know. This is probably under paragraph 3 or 4, I would imagine. But again, I don't know how, if it's a 101 or 102.
You've exhausted my patent knowledge.
I took a few patent classes, but the point being, assuming that they have the right patent rights, I don't know whether it can turn on is it inducement or enablement. But the question, nevertheless, is the first time around, you can make an argument that it wasn't inducement because you didn't even know that the prescription's coming. But the second
the argument here was that by putting the drug on the formulary, you induced members and physicians to use the drug because it was cheaper than other drugs. I mean, that's like arguing that Walmart shouldn't be allowed to exist because it sells stuff cheaper than, you know, Macy's.
Yeah. I think that's a losing argument, my personal opinion. I think what's going to happen...
The judge didn't think it was that bad. Well,
again, I clerk for a federal court judge. The bar for a motion to dismiss is so incredibly hard. Like, you have to literally have nothing behind you to be able to not survive a motion to dismiss. A motion to dismiss is incredibly hard to do. I think you have a better argument at the summary judgment level. Unfortunately, it's after millions have been spent to get to the summary judgment level.
Right.
The problem, however, is that in this specific instance, I don't know how the formulary was set up. I would be surprised if it was set up to basically say, for indication X, use these drugs. Indication Y, use these drugs. Because if you put the vascepa in the second indication and then say it could be used for the second indication, I can see that argument of inducement. But if it was just, these are the drugs on formulary, we're not saying what to use it for.
In this case, the pay edits, the clinical pathways with regard to the prior authorization of this category of drug simply listed out the scientific,
method of action.
Method of action for if this is the condition, then the drug this drug meets the benefit criteria. It's medically necessary. They're making medical necessity decisions. So it's medically necessary for that condition. And it didn't even mention the generic forms of the drug except in a footnote.
Wait a second. So they mentioned the vascepa works in XYZ using the XYZ mechanism of action for indication 1 or for indication 2 or both?
It wasn't split out that way.
Okay.
It was if this is your clinical history,
right,
then that medication is approved.
Okay.
But it didn't go into, if it's good for this indication, but not for that indication.
Got it.
I'm trying to remember what the two indications were. One was
I think it's
like hyperglycemia or
here. I'll show you the screen. You can see it right here, Kenny. Just so you know, it is on severe hypertriglyceridemia, and the second one was cardiovascular risk reduction.
Right.
I don't know which one was approved first. I remember a whole discussion about both of these because just so you know, Amarin's like known to be a big deal in the pharma industry from a lawsuit perspective because they have really gone after the FDA on and this is gonna sound funny to you. They went after the FDA saying you can't regulate off-label speech, and they won against the FDA. So it's interesting that they're now coming back saying that the off-label use can be problematic and be violative of patents. It's a very interesting argument coming from the same company. So we can have.
I don't have a problem with them enforcing their patents. I mean, that's what the patent law is there for.
Mm-hmm.
I mean, you've created something, whether it's biologic or chemical, either way, living or chemical, non-living, organic, inorganic. Whether it's a biologic or not, I guess that's the phrase.
Sure.
Then you should be entitled under the law to, manage that patent. And if somebody infringes your patent, you should be allowed to recover damages. But to put the onus to protect your patent on entities that are not and have never been set up to do that, and really participate in an after the fact purpose anyway. So, I mean, if the idea behind managed care is to reduce the cost of healthcare and to manage that care so that you get better outcomes, which, oh, by the way, is also cheaper, then you're doing something that is not only counterproductive, but diametrically opposed to the whole purpose behind managed care. You're going to tell them that they can't, in many cases, tell a doctor what to do or not to do. But if they tier out drugs so that certain drugs are paid for at one level and other drugs are paid for at another level, still paid for, just at a different level, that they are somehow now responsible for potentially, millions or hundreds of millions of dollars in damages because they've quote unquote induced physicians and members to violate the patent of a company that they know nothing about.
And you'd have to do this with so many companies. It's problematic.
And it's constantly changing.
All right. I think what makes it difficult is Amarin has the strongest argument against the physicians, but you can't sue your customers. So
they just won't.
You just won't survive very long.
Yeah, and why would I sue Dr. X when I'm only going to get, a couple of $1,000s out of him? I'll have to sue, 15 or 16 or 20,000 or 100,000 doctors in individual lawsuits.
Right.
When I can just sue these people.
Right. Exactly right. So we can keep talking about this, and this is absolutely fascinating. I had another conversation I want to talk to you about on the HHS decision on the Biogen drug, which is right here. So I want to talk
Alzheimer's drug.
The Alzheimer's drug, exactly. So I look forward to having that conversation. You've got to come back. We got to talk about this one soon. But I'm going to ask you a couple of things just so people know this. How can people reach you?
Easiest way to get me is to just message me on LinkedIn.
Okay.
It's easier than trying to remember my Kenneth.white@willistowerswatson.com email. You can certainly reach me there. But if you can just look me up, it's Kenneth White under Willis Towers Watson, and I pop up.
Perfect. And I'm going to ask you two questions just so you know. What's something you'd like to ask the audience?
I'd like to know from the audience members, if they think that it's appropriate to put that type of a burden on a health plan, to manage the patent rights of a drug manufacturer. So
I will answer this from two different perspectives. As someone who knows who thinks that drug companies charge too much money and insurance companies charge too much money, my position as the average American would be, one of you is losing money. I think I'm okay with that because the fact is you guys charge me too much money. But at a realistic fairness level, I don't know. I think this is the latest example of a breakdown at the FDA approval process level, which is, I think we're going to land up very soon in a scenario where the FDA does not land up approving the drug for a second indication because no company is going to go, it's worth it to do the additional research. Because a company may be able to approve it for the second indication, but marketing it has been problematic. So companies are saying, why even bother doing that? That's an off-label discussion. On the other hand, from a enforcement perspective, it's going to become more and more problematic, as is seen in this Hikma case. So we'll have to play that out. So my version, I think it's going to be an interesting couple of years from here.
My second question is, who actually thinks that the requirement to have managed care companies pay for up to 8 at-home COVID tests every month per person is going to matter one bit of a damn at all? I mean, my big problem there is, okay, we have to pay for it. You're going to do it, but 8 per person per month at home,
Right.
when it just seems like a massive waste of money out after. I mean, not only the cow, but all the chickens, the sheep, and every other living thing is already out of the barn. And now we're going to run over and put a whole bunch of duct tape over the door to hold it tight. I don't get it. I don't get the whole, let's send a whole bunch of drug tests to people at their houses so that they will ultimately all be thrown away because
Right.
people aren't going to use them. Or
Right.
what good does it do because no one's reporting the data from them?
Right.
I mean, I can stick a swab in my nose every 3 days and use my 8 tests.
Yeah.
What difference does it make?
I had someone ask me, I think the other question is there just aren't enough tests to go around. So,
Well, even if they gave everybody one, I mean, what most people don't give themselves injections.
right.
They're either scared of needles or they're going to hurt themselves or they'll jab somebody else. I mean, with the needle, so they came up with auto injectors
Right.
for certain medications.
Mm-hmm.
Certain medications that people have to have all the time, but then there are a lot of medications that have auto injectors that you probably ought to go to your doctor to get the shot for, as opposed to just having that, because the auto injector is $800
Mm-hmm.
for a month's supply, and the little vial with the needle is $80 for a supply. So you're paying for the auto injector, you're not paying for the medication.
Right.
Well, it makes no sense to me why we would do that. It's the same thing with at-home tests. Okay, if you're smart enough to actually do the at-home test, one, it's just I think they have at-home PCR tests, but you have to send them the sample. You collect the sample at home and still have to send the sample off to a lab,
Right.
or it's the rapid version. But they're
Right.
getting no benefit out of it because there's no one's taking the data.
Right.
Somebody's making money hand over fist of making these tests.
Yeah.
And it's, we've forced people to pay for them.
Yeah.
So, I don't know.
And last question for you. What's
That's
something
what happens when you make a lawyer who has absolutely no history whatsoever with healthcare and put him in charge of HHS.
Well, I'm not even going to comment on that. What's something most people don't know about you?
I probably ought to be on Ozempic, but that's probably visually, noticeable. Let's see. I'm a hunter.
Yes, you are. Yes, you are.
I'm
We
a
had a whole
massive
conversation.
Alabama fan. So
Are
if
you?
if you look at all of, that's my home computer, you'll see the big A's, and then if you see,
Oh, okay. The
all of
helmet.
that stuff up there is
There you go.
Alabama related. If I flip this around, there's more Alabama stuff.
I love it.
I bleed crimson and white.
I can tell. That was amazing. I have now learned something new about you. Kenny, this was wonderful having you on. I'm excited. Thank you again for coming on. Can't wait to have you on again.
All right. Hopefully I'll see you in Philly soon.
I look forward to it.